So we have in the studio this morning to delve deeper into this vexed matters. I have a legal researcher at the University of Cambridge. And also, of course, is a convener of the Fix Ghana movement, Mause Oliver Baka Vamawo. He's joined us as one of our guests. Good morning, sir. Thank you very much for joining us.
Appreciate it.
Good to see you.
Thank you.
And also, I do have the Honourable former Member of Parliament for Adaklu, I believe. Not Dai, sorry. Yes, I know. I know. Yes. Yes. Oh, please, your microphone. Yes, it's on. So yes, he's a former Member of Parliament for the North Dai constituent. That's true. The Honourable John Lowe, he's also a private legal practitioner. And so I have lawyers here. Now, I will shortly be joined by lawyer Kingsley Mwekwa Amwakumboedu. He is the MPP rep. He will be joining us shortly on the show. So these are the two key issues that we intend to look at on the show this morning. So please stay tuned in. And if you have any view or opinion or any contribution that you want to make on the show, please send it to 0244 097934 097934. That's the WhatsApp line for those of you who want to contribute by telling us what you think about the topics that we're looking at. So I'll start with Mausi. He also has a law background. That's said he's a legal researcher, so he has a law background as well. So you should understand where he's coming from when he's speaking quite authoritatively and confidently on this matter. So, counsel, again, once again, it's good to see you. Now, you were in court yesterday, and I saw you with the law professor,
Professor Tia.
Yes, Professor Tia, and Justice Sai and a few other guys. You are well armed with a lot of information as far as this is concerned because you've been following it. You believed in it. Let me ask you this. Were you one of those who joined the group, the eight others, to take this matter to court? I just want to clarify that. Or you're just a keen follower of this particular matter?
So let me give the context, and this is, you're talking about the action against the Imposition of Restrictions Act.
Absolutely.
The action was cooked at the University of Ghana School of Law. I was then technical coordinator of the Democratic Vigilance Project of the University of Ghana School of Law, and we partnered with a number of civil society actors and Fix the Country in challenging this legislation. Now, it was part of a whole range of actions we were taking to check the abuse of power during the COVID period. So we had first organized a series, Law in Crisis, where we're interrogating and challenging certain legislative measures we were seeing. And so the conversation was that the Imposition of Restrictions Act, which was passed, is one of the most oppressive laws we've ever seen in any democracy across board, or even in Ghana. And there had to be a response to it. Unfortunately, the nature of the law and the conversations around it tended to be so technical that it wasn't sufficiently seeming into people's consciousness as to the dangers that were in front of us. But to just give example in the case that we presented to the court. One, that the law allowed the president to assume all the powers of parliament. Two, it allowed it to cast away parliament in making its decisions. It allowed it to exclude the courts. So, and in essence, what the president would do, we had a series of fellow Ghanaians addresses, right, by this thing. Essentially, anytime the president came on TV, he was making law.
See. That's
what the effect of the law is. And we were baffled that parliament would give its powers willingly to the presidency. The whole essence of the democratic, I suppose, democracy is that there has to be a certain separation of powers, that the president will be incompetent to exercise the powers of the president. But that's what the law does essentially. So our argument was that under the Constitution, there's a contemplation for that scenario. But that scenario only exists in what we call the emergency powers situation, which is what the Constitution contemplates would happen, particularly in a grave natural disaster or even in war times. In the US, we call it the war resolution powers. So that when we are in a war situation, the president will be able to assume certain powers. Now, that's not what was done here. Because within that framework, within the Constitution, there are certain checks and balances. One, when a state of emergency is declared, Parliament must meet within 72 hours to consider the declaration of the emergency. Then Parliament may decide to extend it, but it lapses for 7 days only if the president declares an emergency. Parliament may extend it for 3 months and then come back to review it. What the Imposition of Restrictions Act does is that it gives the president the powers in perpetuity. It is not only linked to COVID-19, it is anything the president deems sufficient to apply the restrictions for. So we were concerned about what the power can be used to
so
do.
that explains why the minority at the time were saying that, first of all, they felt that we didn't need it. And secondly, even if the executive was going to push this, I remember there was how do you call it? There was when you're sending a bill to Parliament, there's this, I've forgotten the name, but
yeah,
I
the memorandum? Or?
A memoranda, exactly. Yeah. The minority was saying that the specific, defect that this bill was supposed to be fixing, or mischief that was supposed to be fixing, should have been properly defined.
Yeah.
And also timed.
Yes.
So that you don't have a situation, like you said, he has the powers ad infinitum.
Yes, exactly. One of the things that a lot of the legislations do and have done across the world is that they include what we call a sunset clause.
Exactly.
So that when the time elapses, the law effectively disintegrates.
Right.
You cannot use it anymore.
Right.
We did not have that.
Okay.
In fact, the argument, and I think the minority was also contributing to this, was that the Public Health Act, as it existed, allowed us to be able to take certain restrictions that were within the scope of what is acceptable constitutionally. But that was sidestepped.
Hence the needlessness of the law.
The needlessness of the law to begin with.
Okay.
In fact, I remember when our very first, when I say I'm talking about Fix the Country here, very first demonstration, the conversation around it was that the law did not allow demonstrations. And we said that was constitutionally impossible. Because one of the things the Constitution always does is that there has to be a balancing of rights. So there's a public emergency regarding COVID-19. What other countries had done was that they put in place certain guidelines regarding how a demonstration can be carried out, which is COVID safe. We did not take any of those actions at all. Our public health emergency agencies did not develop any code, any guidelines, did not follow any of the international best practices as to how to preserve constitutional rights, even in terms of pandemic. So it was a real question for us, even when Fix the Country went to the Supreme Court, as to whether or not the Constitution was still alive even in the time of the COVID. So that was the conversations that brought about the decision to go ahead and go to court. Now, in this case, our hope was that the Supreme Court will obviously intervene early enough to be able to check the ways in which this power was being used. In fact, one of the things which, before the Supreme Court decided, we were very apprehensive and fearful of, was that when we were having the conversations around the DDEP, which is the debt exchange program, that we were worried that this law even allows them to go under it and seize people's bonds. Because if you remember, the Attorney General intervened regarding a move the Finance Ministry wanted to do, which is to naturally seize people's bonds. And they told them that this was unconstitutional and they could not do it. We were surprised they had not adverted their mind to the Imposition of Restrictions Act. Because the argument was that the reason why we are in this debt crisis was because COVID-19 had caused it, Ukraine, Russia had caused it. So essentially, they could have said that it was an extension, it was the economic effects of the pandemic. So we had the physical effects, which is the wearing of nose masks and all of this, and then we have the economic effects. Because of the economic effects, this law empowers the presidency to come in and seize
if you want to stretch it, then you can justify it.
Yes, you can justify it. And this was the biggest inherent fear that we had regarding how the law can be applied and when the president determines. Yes. And essentially, because of the way in which it's structured, because it sidesteps Parliament, Parliament cannot intervene and do anything. Anything the president did was legal, and there was no 7 days restriction on it. Parliament could not intervene for 3 months, nothing. Unless, again, you went to the Supreme Court. And if you ended up in the Supreme Court and you were stuck there for 3 years like Domelevo, then essentially it means that nothing was going to happen. So that's where the biggest dangers we thought existed for us. Now, even in terms of how we composed the team, there was a lot of thought and planning to it. So one of the biggest decisions that a lot of people continue to talk about today was what we call the Ray Akoto decision, which happened during Nkrumah's time. And it was a challenge of a colonial era legislation, which is the Preventive Detention Act, which allowed the president to imprison people even before they commit a crime, to prevent crime. And people could be in jail for so long. Now, when this was challenged before the Supreme Court then, it was Akoto, Bafo Akoto, was the chief linguist at Asante Hene's court, and 7 others. So, because of that economic decision, we decided to go with 8 plaintiffs as well, with Professor Appiagyei Tuah and 7 others as well. Instead of a mimicry of what the dangers that portend for our democracy if the Supreme Court did not intervene. Now, till this day, even in law schools, they continue to talk about how the Ria Koto decision was a black spot in our nation's democracy and what. And that's the danger we wanted to highlight too. There were others as well who were writing, like Professor Kwekwaza, who had written and talked about how this law was even way more dangerous than the PDA in Ria Koto. So there's a bit of relief that finally you're seeing a Supreme Court that is waking up to its constitutional role to safeguard our democracy. Some people think that it is a little too late, particularly because the president had lifted all restrictions and had done everything they could do. But I think that the real danger of this law is what could happen even going forward. And so I take the win that our democracy has been somehow secured, by that the risk will not arise.
But listening to Mao say, Honorable George Low, I noticed that apparently this law, in terms of its implications and ramifications, were more far-reaching than we were made to appreciate. After listening to Mao say, and I didn't quite hear the minority articulate it in terms of telling us, and when I say the minority, before minority NDC, and I stand to be corrected, to help us really appreciate the grave danger that we found ourselves in by the passage of this law.
I know. Thank you.
Right.
Put in context the exigencies of the...
Oh, please, your microphone. Sorry. Okay, switch it on back.
Right.
Yes, thank you.
Is it okay?
It's okay now.
Right.
Yes.
We should also take into consideration the exigencies of the times in which we were.
Okay.
Yes, then a minority, like Mauzi rightly pointed out, put out their reservations about the law.
Okay.
But you see, you are in a situation where COVID had come. It was worldwide. People were just scared for their dear life. So, politically, you had to be careful how long or how far you pushed. Because the tendency for people to believe that, look, these guys, they want us to die. And therefore, while somebody seems to be taking preventive measures to secure our lives, they are here talking law. So it was a...
So basically, you had to find a fine balance.
Yes, you had to. And to the extent that at a point, we had the Professor Etua group going to the Supreme Court, we felt that there was no need to do a double stake of this. We were sure
that we have sufficient legislation to deal with this.
Yes, and we were sure about the team that had gone before the Supreme Court. And to be very frank, without any fear, we were also not sure that if it were the NDC that showed their face in the Supreme Court, we may get what we got. It may be seen as a political, you are just doing plain politics. Mm-hmm. That is where. Okay. So if the fine academics and the civil societies was before the Supreme Court to make their case, maybe they may have been seen as neutral in that sense. So basically,
but is that to suggest that our courts or the judiciary take decisions based on who is bringing the matter to court, rather than the substance of what you're bringing to court?
See,
what are the facts?
Yes, at the closer idea.
You want to get judges into trouble, don't you?
No, not at all. No.
I just want to know.
Yes, but you see, when you have a certain perception that has enveloped your thoughts over a certain number of issues, you had every right to believe that you may not get justice. You had every right. It's within your right to decide that I'm not too sure what will pound out for me if I go before this. And let's see this country. The problem we have is that we pretend too much. The hypocrisy is too much. Why? Who doesn't know that to the extent that we even developed the concept of unanimous serving? How did that arise? It arose because at a certain point, everybody was telling you that, Master, don't waste your time. If you go, you get a 7-0. It is the reason why Honorable Kandapa, the National Security Minister, had gone before the justices and told them that the way people are thinking is dangerous for our national security. So do something about it. So clearly, the NDC or the minority in Parliament had some very, shaky things to think about. in respect of this law. But they did raise the issues that the president, this law is not properly before us. The president did not follow due process. And we think that the things that we have in this law are not consistent with what the Constitution talks about. But, well, they had majority, they went ahead and passed it.
Passed it.
Yeah. Because clearly, if you look at the emergency powers that were given to the president, at all material times, even the framers of the Constitution did not contemplate a law per se. They contemplated that president go and brief parliament, and then parliament by resolution would agree with you and give you the leeway.
Within 72 hours.
Yes, or what we even, and then we can review that after 3 months. You come back and brief them, these are the, and that is the reason why the Minister for Interior, when he imposes a curfew in an emergency situation, renews it over time as a result of a briefing of circumstances and things like that. So clearly, the president was totally out of order. And I'm happy that the Supreme Court recognized that this law ought not to have come up at all. Ought not to have showed up at all anywhere in our legislation. So it's good that they struck it out completely.
And at the time, I also recall that the minority were reading ulterior motives into the imposition of this act. And remember that we had the election 2020 just before us, and you had raised. In fact, I had the national, not the national chairman at the time, general secretary. He held up a news conference and said the real actually motive for bringing up this law was to sort of, make it difficult for our folks in the Volta region to sort of cross the border, especially those who are doing business.
Because of the way the laws were applied. And if you wanted to see the sinister motives that the president had,
so were you being real about that allegation? That
let me tell you,
there was a sinister motive?
Even when all of our neighbors had even decided to open their borders for business, he still refused. Look, I was one of those who had to lead the Applaud demonstration, if you remember.
Yes, I do.
And yet the president would not budge. What else would be his motive?
But he had a constitutional mandate to protect us as Ghanaians.
No.
Public safety.
No, because the Constitution, now the Supreme Court have come to tell us that mandate that he assumed did not exist. So he usurped the power of the state. And for me, it's even enough grounds. If we were a serious democracy and we had where the president must answer.
You mean to initiate impeachment processes against the president?
Because this thing that he had done, unconstitutional act, when he has sworn to protect the Constitution, this unconstitutional act has cost us money. Look, all the monies people were paying at the airport and all the things that he did under this law.
Right.
All the things, the freedoms that had been curtailed, all sorts of things that had done.
Your point is, this singular act has social implications, economic implications, and political implications as well.
Yeah.
Right.
So I mean, these are far-reaching consequences than we are that we are contemplating. And I believe that some way, somehow, the president might answer for some of these things. Because you remember the COVID, even the issues of the COVID fund. Now he even went ahead to impose a COVID levy, which people have paid. Mm-hmm. Is he going to refund that kind of money?
Well, he says we should give him time. We should give him time.
No. What kind of time? I mean, there are so many things. Like I said, the consequences are dire.
Let me speak to Prof. Prof led a team to take this matter to court. 8 others, civil society organizations, and he's joined us via Zoom to let us know how he feels about this decision by the court or by this ruling. That's Professor Kwejo Epieje Atia. Good morning, sir. Thank you very much for joining us on Inside Page. It's a pleasure having you, sir. If you please unmute your microphone so that we can hear you.
Sorry, thank you. Good morning and pleasure to be on the program.
It's a pleasure having you too, sir. So what exactly did you take to court? And was this what you're expecting at this particular time, or you expected it much earlier?
We decided to challenge the constitutionality of the Imposition of Restrictions Act, because in our opinion, they didn't follow the constitutional procedures as well as two other acts of parliament which have been promulgated to regulate emergency situations. In terms of the timing, it came a little bit late, but all the same, the decision is still good because the law could have had some future implications on our democracy, human rights, and the respect for the rule of law.
Okay, so you prayed the court to declare it as unconstitutional, and also too, you wanted some consequential orders.
Well, the main request we made, or prayer we made in the case, was to declare it unconstitutional and to repeal the law, to have the law repealed. And our fear and our concern for going to court was about the future use of the law, because the law in the first place was not made to cover COVID per se. There's no reference to COVID-19 in the law. Number two, the law does not have a sunset clause. For any emergency law that is made, it is supposed to be temporary to deal with the particular emergency, so that when the emergency is over, the law should also elapse. But in this case, the Imposition of Restrictions Act had no sunset clause. Number three, the law also had its own definition of disaster, which is very nebulous, unclear, untidy, and framed in such a way that it can lend itself to various interpretations, and which is fundamentally different from what we have, the definition of natural disaster in the Constitution. So we had the fear, and the concern was that this could be used to be applied in any emergency that the government may conjure and determine that it's an emergency, and therefore these restrictions in the act should apply.
I see. So it wasn't really an issue of, but let's talk about the timing, because I've heard people say from 2020 to 2023, that's a bit of a stretch, and that this law should have kicked in, or this decision by the Supreme Court should have kicked in much earlier. Do you belong to that school of thought, or for you it's neither here nor there, or it's immaterial?
It is material, though. It is, because we started voicing out our concerns about the law right from the time it was made. And you also remember the opposition didn't vote for it. And so there was some concerns. But at that particular time, because the emergency was at full peak and people were concerned for their lives and so on, there was not much energy in challenging the law. And so for some reason, it wouldn't have had the sympathy it is having today if it had come earlier. But all the same, a lot of abuses that took place were in violation of the Constitution, because today the law has been declared to be unconstitutional and has been repealed. And so that means that the decision should have come earlier. Yes, but all the same, like I'm saying, it still has its good effects, irrespective of the timing.
So you are just simply satisfied with the annulment of this law. But now that the Supreme Court has made this decision, what does that mean going forward? Does it mean that the president cannot stand on this act or this law to make any decision going forward? I mean, does the Supreme Court's ruling suffice? I think that's the point. Does it suffice? Is it okay? Should it end there?
Yes, the decision is clear that the law is unconstitutional and therefore it is bad law and cannot remain in the statute books of the country. Okay. And so, for that matter, the law is no more in effect, and the government cannot rely on it to make any decision or to ask anybody to do anything based on the law. So that is a good side of it. And like I'm saying, even though the World Health Organization has declared that the pandemic is over, and the president has spoke to us over the weekend saying that restrictions are no more in place, the law is still relevant because the law was not made to deal with COVID. It was to deal with some other things which we don't know, and which would have lent itself for the government to use it for anything that, in its opinion, would have furthered the cause of any governmental agenda.
I see. But does Parliament have to go back and basically but does Parliament have a role to play again as far as this ruling is concerned, or like you're saying, once the Supreme Court has made a decision, that ends it?
Once the Supreme Court has made a decision, that ends it.
Okay.
So the law is no more in force. Yes.
Okay, that's fine. Now, is it enough for? I mean, as far as you're concerned, I mean, once this law has been declared unconstitutional, null and void, you're fine. But people have lost money as a result of the imposition of this law. Some persons may have lost family because they couldn't move from one point to the other to take care of them. I mean, there have been social and economic implications. I mean, as a law professor, shouldn't there be any form of remedies or anything of a sort? Or you think that, look, we should just allow sleeping dogs to lie?
Well, when any emergency decision is taken, when any emergency decision is declared, it certainly affects people one way or the other, some more than others.
Oh, we're sorry about that. There's a bit of a technical challenge. We'll try and get Prof back, and so we can continue with this conversation. I do have in the studio, in case there's joined as well. First of all, we're looking at two big stories that came up in the course of the week, and that's on Wednesday. The Supreme Court made two landmark rulings. One has to do with the Imposition of Restrictions Act, which was passed in Parliament in 2020. The Supreme Court says, well, this law is bad, it's unconstitutional, it's unlawful. And so it's struck it out. And we're trying to look at the implications of the Supreme Court's decision and what that means to persons who may have been affected, etc. That's one. And then also we're looking at the Domelevo. In fact, that's our second topic for today, is the Domelevo's fate has been decided by the Supreme Court. It says the president's decision to ask him to go on leave, accumulated annual leave, was unconstitutional. He should have left him there. And also there should have been some consequence. But the Supreme Court says there's no any consequential orders because the man is already on retirement, and so that's moot. But we'll look at that matter as a second topic. Let me also say that Lawyer Kingsley Amwaku-Boedu, will be joining us. He's had some emergency, but he's promised he's going to be joining us. He's the man who's going to be talking to us on speaking to us or articulating government's position as far as this Supreme Court ruling is concerned. And so he'll be joining us shortly. So because I've had so many people asking, where's the MPP rep, he'll be joining us in a matter of minutes. And also, Professor Kwejo Apieje Etia, we'd have a bit of a technical challenge with the Zoom connection. When we get him back on the line, we'll proceed with our conversation with him as well. But in the studio, I have the Honorable George Lowe, former Member of Parliament for North Dai. He's a private legal practitioner, and also Mause Oliver Baka Vomowo. He is a legal researcher, University of Cambridge, and then also he is the convener of the Fix the Country movement. He's been very much involved as far as this court. This court, how do you call it, going to court on this matter. I'm talking about the Imposition of the Restrictions Act is concerned. And so he's given us a bit of a background and why he and his group decided to be a part of this advocacy. So I'll come back to, I think you were on the floor when I
Yes.
So I'll come back to Mousy. So Mousy, I was asking Prof, and maybe you take it from, no, first, maybe even before I come back to that question, the fact that the Supreme Court, I need you to educate me on this. So once the Supreme Court has made a decision on this, it means that the law doesn't exist anymore?
Yes, not only in this case, not only does it not exist, it did not exist in the past because it was void when it was passed. There was no power to even pass it in the first place.
Okay.
So essentially, well, I'm not going to say it takes effect retrospectively.
Okay.
But in fact, it is as if no law should have existed at the time. So that brings in question, I think the question you were asking him,
yes, about those who were
actions
affected,
which were taken in respect of that. I know some of the research we did, we know that some certain people had in fact been jailed in respect of the law.
That's true.
Yeah. What does that imply and what does that mean for their fate? If they have already served their term, what does it mean that they have to be compensated? In fact, one of the arguments we're making is that when you look at the regime the Constitution creates for emergencies, it is such that it puts a role even for judges to review the basis of people's detention during an emergency.
Right.
The law takes away that power as well. And so people are deprived of the benefit of having judicial review of why they will be detained in a public emergency. So yes, there's a basis for which a claim could exist. Now, but there's a murkier question as to whether or not power exists for the president to impose restrictions in a time of emergency like that. And we argue that that power existed under the Public Health Act.
Okay.
The difficulty, however, is that at no point did the president claim to be acting under the Public Health Act. And so that creates a bit of, if, for instance, they had said, well, we are taking this restriction on the basis of the Imposition of Restrictions Act and the Public Health Act, then you can say that, well, when one fails, they are saved by the other. In this case, that doesn't happen. So yeah, it throws up a lot of murky issues. I don't think, if it was another jurisdiction, we may see a lot more claims on the basis of the actions taken here come up. I don't think that this is going to happen here. One, because of, well, the poverty of so many people who are affected by this decision, the cost of procuring legal representation.
But it doesn't mean somebody can take a class action.
It is possible to take a class action. Unfortunately, our biggest interest in trying to do over the past 3 years, I've noticed, is trying to build a class action. It's one of the very difficult things to do in this republic. Well, first of all, I remember when we tried it in the context of recruitment into the military and security agencies, the selling of forms to citizens, which we think violates people's right to fair and equitable employment in the public agencies. And we reached out to so many of people who had been rejected, even though they're taking their money for forms, when we know that we have less than 3,000 roles available, and we are selling forms to over 30,000 people. There's a bit of, inequity in that. When we reached out to so many people were like, I'm interested in the matter, but keep me anonymous. You can't be kept anonymous when you're going to court. So there's always a psychological fear that exists in the system when people want to challenge abuse of power of the state. So there's that one. Also, the second thing is that even in terms of the rules of court, our rules of court have no particular framework that deals with class actions in a way that exists in other jurisdictions. So the point where people might be able to submit a list to the court will certify the existence of a class, and then the rules that would operate normally in terms of individual actions will be different for them. We don't have that. So it means that you have to prepare, if you're preparing whether witness statement and you have a class of 3,000, you're preparing for each individual person. In fact, there's a court case that if you don't list every individual person that is affected, then they cannot be subject to any claim. It's really, really difficult. So we may talk about it notionally, but in fact, it's not practically something that can be achieved. So yeah, those are some of the ways in which our democracy, I think, is impoverished.
Yeah, but the thing is, and I'll come back to you, Honorable George Lowe, that the laws are quite clear, aren't they? I mean, when it comes to how to deal with matters bordering on the fundamental breaches of somebody's rights. And clearly, from what Mao has said, somebody's rights have been abused.
Yeah.
Because a law has been legislated, which shouldn't have been legislated in the first place. It's been legislated, never mind. And it had some grave consequences on some persons. If today we decide to do an announcement and say, if anybody has any evidence that following the passage of the Imposition of the Restrictions Act, so and so has happened to you, which borders on your fundamental human rights, come to us and we'll take an action. You can imagine the number of persons who will come, to you. So how then do we have a law that says when somebody's rights are infringed upon, the laws must deal with it, the courts must deal with it. And yet we have a situation, like you said, there's real difficulties, even in dealing with situations where somebody's fundamental human rights have been dealt with, and yet it's like you're helpless. Well, what kind of legal regime are we running?
You see, it is not about legal regime simplicity.
Right.
But it's about our whole mindset as a people.
Okay.
So, Moro, you have an issue. Charlie, I have this issue. Charlie, can you take it up for me? But Charlie, I don't want to be known. How can I work for a ghost? It's impossible.
Right. But that's just one leg of the challenge.
But I'm saying
you mentioned something else.
Yes. You see, the other thing is the procedures as they are also become a hindrance to people assessing fair judicial intervention.
Okay.
So clearly, he is pointing us to a situation where we may have to sit down and revolutionize our whole mindset. And I'll tell you, I mean, when we get to the Domelevo issues, one of the issues I spoke to on a sister station the last time, how does our courts understand their mandate? You understand?
I get it.
You see, as a court, the way is to be understood, right? They are the protectors of your freedom. They are the protectors of your rights. They are the protectors of whatever you are seeking. And then, more importantly, the judiciary is a tool for development. People don't seem to understand that. And it's one of the things that have been missing in our discussion over time. How have they lived up to their developmental role as an organ of state?
Okay.
You understand?
Yeah.
So all these things are things that we need to talk about. First and foremost, like Martin Pebu said much earlier,
Right.
the organ of state that is supposed to liberate the people through education, particularly civic education, they have failed woefully because it has been over-politicized. So NCC, which is supposed to, over time, have district offices, have district officers holding fora, holding seminars and educating people on their rights, what you can do, what you cannot do, and how you do it, and how to assess this. They don't do zilch. I can challenge you. Go to any of, particularly those in the internet, and find out if you see NCC that has a bicycle. At best, you get a broken down one. It exists on paper. It doesn't exist in practical.
You're suggesting that we don't seem to be interested in resourcing and empowering the NCC in order for them to empower the people knowledgeably.
Of course.
Because the more knowledgeable the people become,
Well, yes, then
the more they'll demand.
Yes, because they'll demand and then they will take
accountability and
action.
so on,
And
yes.
then they'll become confident. Why?
So we're happy to keep the people.
Yes, let me use Mause's example. Would you think that, or do you know why somebody will say, I don't like this thing, but I don't want to be named?
Right.
For instance, when you have visibly gone to buy a form, possibly being given a slip to show that you've purchased the form, you have a number. And therefore, you are somebody who has acquired capacity because you have an interest in the matter. And then you say you don't want to. Do you know why? The man is thinking, hey, what if I can get some protocol connection under it, please? If I take government to court, don't I close? Or what if I want to go to another government sector? You know, some people even buy immigration, police, prisons, but all that.
Try your luck.
They keep trying. And so he thinks that, hey, if my name shows up on any written that I'm challenging government, I'm done for. My opportunities are closed. So those are the things that people worry about.
Right.
So you have workplaces where you cannot even get colleagues to testify for you in an event because after testifying for you, when I go back, what happens? Because we also have laws that for me are not progressive enough. If you look at our labor law, where you have been told that, well, as for what do you call it? Apart from the fact that you've done something, you are illegally sacked or something. As for, say, what is the term? They can, once they pay you 1 month in lieu of notice, you can be asked to go.
Yeah, you can.
And you have no real remit. So all these things play into people's minds. And, you know, the poverty around. The salary may not be good, but at least there's a paycheck.
Right.
So a lot of, in fact, there's a lot that we must do as a people if we want to really call ourselves a democracy. Right. If you really want to call ourselves a fledgling state.
So the mindset factor
is very huge.
Is big.
Huge.
And that's why we're not able to test the law.
Yeah.
Relative to some of these
in most
things.
cases.
And so you have a situation where somebody's right, yes, maybe it's been infringed upon, but he feels he has more to lose when he goes to court.
Of course.
And showing up and saying, this is me taking on the system. You know, well, they've seen what's happening to Mause anyway, so why would they want to?
Yeah. I'm a bad poster child for anybody to feel confident and competent that,
you know, I'll come back to Mause. But 0244 097 934 0244 097 934. So that's the WhatsApp line. Please feel free to send us your view about what you make of this conversation we're having about the Supreme Court striking out the imposition of the Restrictions Act, which gave powers or enabled the president to determine, what to do in matters of in matters of emergency. Some have said, well, there's enough legislation in the 1992 Constitution as a Public Health Act of dealt with it, but the president decided to still get the executive to table a bill in Parliament, which then became the Imposition of the Restrictions Act. So that's what we're talking about. We're looking at the various facets and legs and arms of this particular issue. Now, Mao says, let me read something from Jason. Jason makes a very interesting, thought, expressed a very interesting thought on this matter. And he says, the least the minority could have done is to have advocated a sunset clause in the Restrictions Act. But I recall, Jason, that the minority, in fact, Muntaka Mubarak, yes, I vividly recall, he had advocated that. Jason, that's the truth. I mean, he passionately made a case for that, but I think it just didn't work. But again, he said, advocated a sunset clause in the Restrictions Act. That is, if they claim they were being cautious in the face of COVID-19. The truth is, the major political parties differ little when it comes to constitutional fundamentals in this country. Reason why the two major parties are yet to make sweeping changes to the many flawed elements in the 1992 Constitution itself. So that's from Jay saying, that's expressing his thoughts on this matter. This one says that Nanaya Boateng from Awoshi says, good conversations, great panel. I am enjoying this. Please keep it up. But who says the president didn't know he was infringing upon the rights of the people? He knew exactly what he was doing, but we all know what the end game was. Thank you very much, guys. Anyway, so that's Nanaya Boateng from Awoshi. There's quite a number of other messages here, but I'll come back to my resource person. So 0244097934, that's the WhatsApp line. Please do let us know what you think about the conversation we're having. Anyway, so Mouse, I'm going to come back to you about, you said there's this real difficulty, because I'm still saying that yes, the Supreme Court has done what it's supposed to do. I'm also going to ask you whether you were expecting it to have come earlier, and whether if this had come earlier, it would have made any difference. That's my first question to you. And two, with all the challenges that you have, eloquently enumerated, which makes it difficult for persons to take this matter up if they feel that they have been, hard done by. Now, if another president comes to have another president tomorrow who decides to do whatever it is he wants to do, my point is, shouldn't there be any consequence for these kinds of decisions?
Yeah.
In order to demotivate any other persons or to discourage somebody else from taking up, just waking up one day and deciding that, look, this is what I want to do based on what I feel is right for the people.
Yeah. Let me take the second one first, and I'll come to the other one. I know that the conversation for so many people about what then happens to so many people whose lives were affected by this, what does this mean?
Yeah.
And sometimes it's even very difficult to quantify.
Okay.
Joe was talking about, the cost of it, but sometimes it's also very difficult to quantify it in terms of the human bones that are lost by persons who are affected at the border, as you talked about. And for some reason, even in terms of how it is administrated, you have a situation whereby persons who could fly into the country were being allowed to fly in. There was a system put in place, but persons who were living in border towns could not see relatives. Families being divided. We're a nation which was torn apart, which tears apart families. And it is mindful that even in building a republic, that we are mindful of the historical legacies of what the colony did to us. But even in terms of law administration and how we went about it, there was no thought to how this would affect families and people who were able to visit each other during this period. Persons who have to plan funerals, but persons who have lost lives during the period. What does this mean for them? One of the ways in which you can think about it is that you don't necessarily have to judicialize all of it. If we thought about the framework of, say, Shraj, for instance, unfortunately, one of the things we've done with Shraj is that we've clipped its wings and saying that it cannot act unless it has received a formal complaint. But if it is a true and proper ombudsman in the way in which it was contemplated,
able to act proactively.
Yes, it will act proactively to try to reach out to a class of victims who are affected, who think about restorative justice in ways that are affected by persons who are affected by this. These are the ways in which you complement the normal processes of how the judicial system is supposed to work.
Okay.
But we've judicialized even the Shraj process, unfortunately, as well. So that's one of the ways in which I think we can think about how we help people. In terms of what are the repercussions for, to discourage this kind of conduct and behavior going forward, I think that it's not as pronounced here as we would see when it comes to maybe the Domelevo case. But what we have seen here is that there was a failure of institutions on so many levels. So not only are the presidency taking the initiative, the refusal to listen to critical voices that are speaking, but also Parliament's role in the process and what that entails, right? And I know that, of course, because our Parliament is politicized, the actions that may be taken by the majority that the minority has to assume, because it is an act of Parliament at the end of the day. But the truth is, one, there's so many ways the minority can protest, whether it is, we saw the vibrant opposition to the e-levy, for instance, and I would have loved a sort of a similar opposition to this law, aware of the dangers of it, But the record, and I think the Hansard reflect persons who stood up and spoke against the law. At the end of the day, that's what we have as a nation. That when we are thinking about when these things come up again, we can reach back into the annals of our history and say, when I look at the Hansards, this is what some of the statements people made against this. When I look at the civil society space, this is what the statements that were issued, and when we look at the courts, this is ultimately what the courts did that enhances this in that regard. The second question, the first question was about whether this should have come sooner.
Yep.
I think for me, one of the things that my advocacy and the kind of work I'm doing is to try to create an imagination in people's mind about being able to speak up against abuse of power, and to people to feel more confident in doing so. If this law had come in the thick of it, it would have reinforced for people the sense that the president is not the one and only person who can do everything in this country and get away with it. It will create a sense of, a sense of belief in institutions that check the president's powers. Right now, people are looking at it and said, what is the point? The president got a head start and even came to announce and lifted all restrictions. It feels like it doesn't have the same psychological effect in building a democracy. Democracy is sustained by the belief that there are checks to the powers of those who hold power. And if we don't use every opportunity to reinforce that psychological feeling, people will continue to feel that, what is the point? That's kind of where I think that something is lost.
Did you also ask yourself, why did you have to take 3 years? When you heard the ruling, did you ask yourself the same question?
Of course. You see, earlier on I pointed to you that sometimes when you do a personal analysis of some of these things, then you begin to ask yourself, really? So is this the end game? Because you see, have you thought about the fact that the president comes on a Sunday evening to say that I am everything has come to an end, I'm lifting whatever, and then I think Monday or Tuesday the Supreme Court goes ahead, to say that it is unconstitutional. Did he have wind of the likelihood that they were going to really declare the law unconstitutional? Why did he have to, when the real reason he told us he was coming to talk about was the IMF and its conditionalities? Why did he have to smuggle in COVID-19 and its restrictions and things like that? These are questions people ask themselves. Right. And it takes your mind to... So, yes, the president at all material times knew that he was playing a game with Ghanaians. He knew that he didn't have the power to do what he did. He did it. And for some of us, we even believe, because of these frontiers issues that are come and things like that within the COVID period, people did it for gain, for financial gain. And if the audit report on COVID-19 comes to be slotted in, then you see where I am going. It's sad for this country, but like Mause said, we can always look to a more pleasant future, particularly, at least, we can say that this particular president under this law, never again will he have the power to use this law as a vehicle to perpetuate much more pain on Ghanaians. At least the Supreme Court came late in the day.
But better late than never.
But, that theory doesn't work with me. I don't like saying better late than never. When we can be better, let it be better.
You think it enhances or it encourages mediocrity?
You see, Moro, I worry for this country because when I hear some of my colleagues at the level of a certain political hierarchy say something like, as for every program, when you roll it out, there are bound to be challenges. It's a very mediocre way of thinking. Nobody should. Meanwhile, you tell me that, I get angry. Who says that we cannot sit at this table and develop a program, do some real inbuilt monitoring and evaluation and get it right throughout? Does every program that is rolled out in the UK and the US fail? How can you tell me that you are rolling out a free SHS and you did not know that the numbers will increase year after year? So all these things that people come and say, oh, it's better than on left, but it's a new program. There are about to be challenges. It is total. I mean, I don't want to go there.
It's total rubbish. That's
I mean, that's
fine.
That's
we use that to make excuses.
Yes, you can find an excuse for everything. And that is what we do at our
Right. I would ask my.
No, there's a thought that came to my mind, and I think it's something that I've also been thinking about. Particularly Parliament's inquiry into the Minister of Health, the actions the Minister of Health took with respect to
Sputnik V.
Yes, with respect to procuring the vaccines and so many of the things that were done where his official response was, I wasn't thinking. I think this also brings us back to those conversations about the responsibility and the responsibility question again of certain things that were done in the period, things that cost us a lot of money, things that injured the full faith and good credit of this republic, and what are the actions we are going to take in respect of those. My hope is that it's not something that we push down the line and say, well, if a new government comes in, then we'll go after former officials over this. But a sign of democratic maturation is that even under this government, you have an Attorney General that is taking initiative and saying that certain things were done that undermine the good laws of this country.
In reality, that won't happen.
Pardon?
In reality, that won't happen.
Oh, well, it's only because we have an individual in Attorney General's office who himself, as an individual, and I say this thing, does not have the belief in the democratic process that we have, that every action he has taken as a Minister of Justice is to undermine our democracy than to enhance it. So I don't have faith in him as an individual, but I'm talking about the role and the weight of that office. And it's unfortunate that we have somebody who's not filled the boots of that office properly. But whatever the case may be, he's a representative of the president and his reflection on the president himself.
The tragedy of seeking redress in such cases is that the overreaching leader who passes the draconian law gets no personal penalties. Rather, the tax monies of the mini poor taxpayer is what is again used to compensate for the parochialism of such entitled leaders, until a constitution which takes away the sweeping powers of the presidency to make such self-serving decisions is promulgated. We will continue the weeping and the wailing accompanied by the legal musical chairs of seeking redress to no conclusive end. The 1992 Constitution itself and the powers it grants the executive presidency is at the very roots of these constitutional abuses. The problem must be tackled from the roots. This is not to take anything away from the thankless job Vamawo and the team have done. The hope is their efforts will propel a national groundswell against the inequitable constitution document which makes such violations of individual rights very easy by the most powerful man in the land who should rather be protecting the vulnerable in the land. Jason, thank you very much for that message. So we're going to take a break. When we come back, Domelevo, according to the Supreme Court, shouldn't have been asked to leave or shouldn't have been sacked in the first place. Now, the question isn't so what? What happens next after the Supreme Court's decision on the former Auditor General, Daniel Yao Domelevo? I'll take a short break. I'll be right back. All right, welcome back. This is Inside Pages on Metro Television. Thanks for staying with us. Now, President Nana Addo Akufo-Addo breached the 1992 Constitution when he directed a former Auditor General, Daniel Yao Domelevo, to proceed on leave in 2020. That's what the Supreme Court has said in a unanimous decision. Now, in that decision, it was a 7-member panel of the Apex Court also held that it was unconstitutional for the president to have appointed an acting Auditor General when Mr. Domelevo was still in office. And this is what the panel said. We declare the directive by the president appointing an acting Auditor General when the substantive Auditor General had not retired or been removed from office purportedly in accordance with Article 146 of the 1992 Constitution as unconstitutional, null and void, the court again declared. It was the considered view of the court that the directive of the president, Mr. Domelevo, to proceed on leave, which was contained in a letter dated June 29, 2020, and signed by the Executive Secretary to the President, Nana Beditu Asante, violated Article 71, 1877, A1, that's of course 12, 13, and 146 of the 1992 Constitution was therefore null and void. Article 71 of the Constitution deals with the power of the President to appoint certain public officers, including the Auditor General. Article 1877 stipulates that the Auditor General shall not be subject to any control or direction when performing his functions. And all of this started in this just before June, when the Auditor General decided to look into the activities of Crow and Associates, and that's when his woes began. And Crow Associates had a link with, at the time, the senior minister, Yaosafo Mafo. In fact, that's the theory, that because he decided to look into these matters and said that Crow and Associates had no business, the state had no business paying Crow and Associates, some actions began to be instituted to make sure that they get rid of him. So that's what some people believe. And I'm not saying that's true or not, but that's the theory out there, the conspiracy theory out there. So Domelevo has been asked to go. And remember that his mantra has been, when you're fighting corruption fights you back. I remember all of that. He's been saying that quite consistently. So we're going to come back and ask, so the Supreme Court has made a decision, and so what? You know, can Domelevo, for instance, take any actions against the system? Or he should, for himself, he said he's going to allow sleeping dogs to lie. He doesn't intend to take any decisions. Because for him, the most important thing is that what he's been seeking for, justice has been delivered. He doesn't believe in justice denied being justice, justice delayed being justice denied. But I'll pick the thoughts of my guests who are here. Mause Oliver Bakavomawo is a legal researcher, University of Cambridge, and also the convener of Fix the Ghana Movement, and also a former member of parliament, a former lawmaker for North Dai. That's Honorable George Lowe. He's also a private legal practitioner. Now, we had invited Kingsley Makubuedu from the MPP. In fact, the MPP had dispatched him to join us, but he had an emergency this morning. But he's promised he'll be here, even if it's just for 30 minutes. So we're still waiting for Kingsley Makubuedu to join us to tell us what he makes of the two decisions that have been made by the court. So let me read this. This one says, Moro, the irony of the Daniel Domelevo matter. And okay, so this is about Daniel Domelevo. So I'll read it. And in the course of the discussion. Anyway, so here we go. I'll start with you again. I don't know if I should start with Mouse or George. Anyway, anything, it's all same. I'll start with George. What was your initial reaction when you heard about the Supreme Court's decision or the judgment on Domelevo? What was your initial reaction?
Well, my initial reaction was to what end?
Okay.
In this particular one, to what end? I mean, here is a man whose rights, his right to work, to earn a living, had been taken away forcefully, okay. And then you sit down for like 3 years, and then when he has been booted out of office and he's starting a new life, you come back to tell us that whatever was done to him was wrong. You see, I found that not good enough, and I mean I said it with all confidence on another platform that I thought that the Chief Justice did not live up to his expectation. He did not live up to his responsibilities as Chief Justice.
Made outgoing Chief Justice.
Yes, Chief Justice, because he has a duty of empaneling people to deal with the matter. He may have done that, but what was his supervisory input? Because you see, like I said, the Supreme Court was not set up to just adjudicate cases or to as it were, be the last court, the court of last resort, or to interpret the Constitution simpliciter. The Supreme Court is a critical organ of state in our developmental process. That is why they've been given powers that nobody else has. In fact, they have been given powers to look the president in the face and say, Master, this thing that you did is wrong. No other court really has that kind of clout. So if you delay in the performance of your duty, you see, the Constitution says what? Justice emanates from the people. So the people are your first line clients. Your duty is to them. So if you do not perform a duty that helped in resolving issues timeously, then you are failed. That is for me because look, there have been cases that came after Domelevo was brought to the Supreme Court, and yet they had been dealt with. There are other cases that have been dealt with far more dispatch, that did not have such repercussions. Don't forget, in human rights issues, he says it's better for one criminal to be freed than 10,000 people to be put out there. You understand? So, for somebody as critical as Mr. Domelevo, one who proved to be the number one fighter of corruption, which also turned out to be the most critical cancer that the nation was suffering from. You know, and how many months, weeks should it take the Supreme Court to realize that the president was acting ultra via his powers? The Constitution is clear. As they themselves have said, the Constitution is clear. The Constitution, if every student of politics who read the Constitution, or even lay person who understands English sufficiently, knows that the president cannot touch the Auditor General, like he cannot touch many other people, including the judiciary. And that he cannot ask people in his office to write to the Chief Justice, let alone also write to the Auditor General and say, Master, your leave is overdue. No, there's an audit service board. You understand? And even worse is that when, like in all institutions, the Supreme Court, any year is gone, who is acting? Is it not Doche JSC? Did any law, has any law? It is just the convention that the senior most will act until set. So why would you go ahead and appoint an acting Auditor General? Did Domelevo have a deputy? Is it not logical that when even he himself chooses to go on leave, the logical thing is his immediate deputy would act? So clearly, again, the president knew what they were doing. The NPP knew what they were doing. Already the senior minister had taken on Domelevo like never before, before the same Supreme Court in other matters, in the Kroll and Associate matter, because he dared challenge the senior minister's role in that. And so clearly they were out to get him. The Supreme Court, they don't live in oblivion. The judges live in Ghana. They know what is going on. So we were expected that they'll be more proactive. In other parts of the world, the Supreme Court rises up to the occasion to correct wrongs. Particularly when, in these cases, we did not even see consequential orders. So, in the past, when we dealt with Salah and the Attorney General and things like that, era is gone. All over the world, go to the Commonwealth and read their judgments. Read the judgments of the Supreme Court in Canada. Read the judgment of the Supreme Court in Australia. They always rise up to the occasion. In fact, in America, things that are not even before the Supreme Court are taken up if it's necessary and dealt with conclusively, if that would conclusively deal with a certain matter. We expect, that's what I'm saying, that the Supreme Court is also a part of the developmental organs of the state. We want to see a Supreme Court that will rise up to the occasion and give judgments that lead to further development of our state. But where they have to sit down and somebody suffers an injustice for this length of time before coming to say, if it were a death sentence, he had been sentenced. So then we come back and say what? His family should be compensated or what? I mean, I believe that the Supreme Court had what it took to expeditiously deal with this matter. And I put it at the doorsteps of the Chief Justice. Of course. The man had...
Sorry about that. I'm told my microphone was off. I'm so sorry about that. But you talked about the fact that, even more unfortunately, is the fact that the Supreme Court failed to give any consequential orders. My question to you is, what kind of consequential orders would you have expected the court to have given?
Well,
in this case,
Mause mentioned something. He said that, you see, when you go to court, there are expectations. Where your rights have been taken away, right? Some restoration must be done.
Okay.
You understand? So if the Supreme Court says that, okay, Mr. Domelevo, you were wrongly dismissed from office. The law or the act itself was illegal and unconstitutional. Okay, what directives are they giving to the executive who took that action? Well, when you go to court, it is not every relief that you have to plead. He knows.
Oh, I see. I thought you have to be more specific about what you want.
It is not every relief that you need to plead. You understand?
So the court can use their discretion to direct
the Supreme
reliefs.
Court
is a very powerful
It's
court.
a very powerful court. It is the Supreme Court.
It's the highest
Go
court of the
and
land.
read Wade versus Board of Education, all those cases in America, and look at the thinking of the Supreme Court. You see, there is something we call public policy, right? And all those things form part of the gamut of avenues available to the Supreme Court to make declarations and also to make rulings and judgments and things like that. I believe that our Supreme Court has limited it. I'll give you the only, in fact, I said to somebody for a very long time, the only judgment that the Supreme Court had given, that I thought that they had done what I expected of them really, 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 in terms of consequential audience, was the Abu Ramadan case.
Right.
You will notice that in that case, after saying that you cannot use NHIS card to register as a Ghanaian to vote, they went ahead and said, look, you see, we are giving you this period and this period. You remember that they actually invited the EC to come and find out whether they can purge the voters of those.
Taking the list of persons who use the NHIS card to register.
And gave orders that if you can do it, then go ahead and do it. Clean the register. You see the difference?
Wasn't it because Adamu, Abu Ramadan had asked the court to do so?
No. You see,
he only went to the court to say.
He said that one cannot be done, and that people's names should be taken. But I'm saying that the Supreme Court actually took time, to invite the EC to find out whether it's doable and ask them to do it. You see, then you are solving a problem. You understand? So I believe that, so far as I'm concerned, I'm happy that we are having a new Chief Justice. She should take a step back and see if we can do things better. After all, this same Supreme Court, when it came to election petition, did they make practice directives and things like that and said that this thing must be handled within this period? Yeah, same Supreme Court. So why can't they do it in things like this? Because these are very grave matters for individuals. Look at the way, how do you think Domelevo will feel when he was being handed out of office? As if he was a common criminal. To the extent that they even created his age for him. In actual fact, the state disagreed with the age that he said and had to use that to get him out. So it's not palatable times for him at all. But being the principal man that he is, he says to the extent that the president is not paying tax personally, whatever money they used to pay him be other people's money, which he thinks he doesn't deserve. So he's saying that, well, to that extent, he's leaving. Let's move on. But at least he's made a case, and we should be guided by that moving forward. And we have so many cases, and there are so many things.
So this issue about the length of time that the Supreme Court, our courts take in adjudicating matters before it.
But even before we even before we get there, I just want to make two quick. Look, even in their interpretation of the Constitution, sometimes I am worried and wonder if the Supreme Court
is alive to the realities of our times.
Alive to the realities of our time. Two, really contemplate what the framers of the Constitution envisaged when they were drawing this Constitution.
Or intended.
I'll give you one example. Did you ever think that those who sat down, both the experts and the common people who came up with this Constitution, contemplated that there will be a district or a constituency called SAL without a representation in Parliament?
I don't think so.
Did you think that at any point in time they thought that Asin North should stay, residents of Asin North, taxpayers of this country, should stay without an MP by way of injunction and things like that? So sometimes when the decisions come, you go back and say, hey, good morning. What is happening here? Because I don't ever think that anybody in this Constitution or any framer of this Constitution contemplated that parts of Ghana should stay without representation in Parliament.
Well, what you're saying, it brings us a sharp focus, this whole talk about the fact that we have a Constitution, but we're not practicing Constitution.
Yeah, because I'll say, you think about it. Did they ever contemplate that?
The implementers of the law have failed us. I think that's the point you're making. So we don't have constitutionalism, isn't it? Anyway, but that's a whole topic we can have. I think you've delivered. I think you've delivered a lecture on that before. I think whatever you or someone. But that's fine. Now, where do you stand on this, Mausi? I mean, you heard the Domelevo thing. I mean, how did it jump at you? What were you thinking? What were your thoughts?
So one of the things, particularly because our end into the conversation is the Supreme Court's intervention now, I'm worried about is that our conversations around it would be so centered on the court that we forget how we got here.
Right.
One of the things that to this day I am unable to fully apprehend, even the government's approach in this matter, was these conversations around Domelevo being Togolese. You see, it seemed like a throwaway thing, and we had to find every other ways to get the individual out. What it reminded so many Ghanaians of is the trauma of a government whose whole policy is to externalize or treat persons of this country as foreign. And there's a whole sentiment that exists within large portions of this country, in our communities, who have consistently been made to feel othered in how we are building this republic. This language was prominent even around the elections period, where there was a whole conversation that for some reason, when we are thinking about foreigners coming to vote, is always within the Ewe areas. This continuous contrived attempt to alienate people is something that we are playing with it, but has a long history. And as they say, the axe may forget, but the tree never forgets the injury that is done to it. So I remember the vive conversation that this erupted at the time. The second thing is, somebody was telling me that, listen, Domelevo, Amidu is an example of what happens when you want to be able to abide by your constitutional powers and use them to the effect that the Constitution intended for you. That's to live up to a certain principle in office. What this sends across board, and I have been a civil servant before. I was in the Ministry of Foreign Affairs for some time, and I've talked about how there's so many people within the civil service whose whole approach is that I need to hide myself, if not, they'll chop off my head. And so you just play by the rules. But the Constitution never contemplated, or our democracy never contemplated, that persons would be, or our civil service would cower in the face of political manipulation. This invites them too. Thirdly, the Supreme Court's role in this conversation. Unfortunately, I think that we are talking about the delay of the court as if it's something of an administrative function. I don't think so. I think it's intentional, and it's also a reflection of political capture of the court. Because one of the things the court has done expertly, for some reason, administrative or whatever it is, delays disappear when it's something the executive wants. You can think about the Justice Abdullahi case, which concerned the right of the deputy, deputy speaker to preside and vote at the same time. For some reason, when it needed to advance government interest in that matter, they pushed it forward and allowed the e-levy to pass in connection with that. But when it came to the e-levy, which has been challenged by Honorable Samola Blackwine and Haruna Idrisu, that they must put on ice. Anything that is something that is challenging the abuse of power, the court is not alive to expedite it or take certain actions in respect of it. That is, for me, evidence of capture. And when people talk about political influence or political bias in the court is always suspicious and hurling everybody before it. Apologize or we'll send you to court. You can drag 1,000 people to come and apologize before it. It would not change the people's psyche about your inability to stand up to the executive. It is not going to change that. So that's, for me, to be able to garner respect in the courts. That's something that we have to take into account in terms of how we are building a nation. Thirdly, when it comes to that particular office, the circumstances under which Domelevo was sent out of the office, and the context, and you said the context, that this was somebody who was going after the senior minister. It is only in situations whereby other constitutional actors go against the executive do you see democracy's better function. But when they do that, and the approach is that we must kick them out of office, then what aura does it create around this whole regime? Everybody looks on and says that I'm not going to get myself involved in this particular matter. It doesn't resolve the problem, because what they created was that immediately was handed out. Acting Auditor General is coming, says that we've reviewed it, everything is fine. What are you saying? It's like organizing your match and choosing your own referee, and the referee comes and says that we've decided that we won't play the match again. We've awarded 3 points to the other party. This is not a democracy. Even in the darkest periods of this country's nation, we have never seen something like that happen. And for me, I think that this Domelevo decision, which, as far as I am concerned, in our history, the first time in our history that a president or the head of our executives has been found to have acted unconstitutional, since
Okay.
Buzia.
All right.
Buzia in Apollo 3 case.
Okay.
This is the first time the president. Yes.
I think you're hitting the.
My chair keeps sinking.
Yes. You're just sinking. So,
and I keep going down.
So we're going to take we're going to take the camera off you for just a few seconds, so we'll sort you out, and then we can come back and do this. So in case you just joined us, we're having a conversation about the Daniel Yao Domelevo's matter and the decision that the Supreme Court has given relative to how he was. He was gotten out of power. Out of his office, the position as the Auditor General. And Mause, who is a legal researcher at University of Cambridge, has been given his own thoughts on what he makes of the Supreme Court's, posture and the way the Supreme Court has handled this matter. He thinks that the Supreme Court could have done better. Yes, please go ahead.
Yeah, I was saying that, you see, when you think about all the other situations that we have had before the court, if the court overrules a law, let's say the Imposition of Restrictions Act, it is very difficult to tie it into a particular action the president has done or taken. In this particular case, this was the president's own actions that were found to have undermined our constitutions and thus disturbed our democracy. Since Buzier's time, when the dismissal of certain officials who were suspected of having CPP affiliations, we have never had the Supreme Court declare the president's action as unconstitutional. This is significant. For me, it erodes the president's legacy and everything he claimed he stood for before he came into office. I would have hoped, and I've always talked about how, for all the things this president has done to our democracy, I would have hoped that an attempt to impeach him would be on record. Even if he doesn't succeed, he will be the first president on record to have been an attempt to impeach him. For me, I've seen Parliament fail to take any initiative in that regard. For me, this does it for me. The fact that the Supreme Court has found that this individual intentionally and purposefully undermined our constitution is sufficient for me. Because I don't see him standing and holding his head high anywhere in any respectable forum to say that he helped advance and push the ends of our democracy. It is gone. Now, as to what we as a people do with, the court has decided, we as a people do with this information, it's critical. And you've talked about other democracy. In other democracy, this would have mobilized a whole movement, getting him to step aside. Nixon did the same thing when he was found to have breached the laws. It wasn't even the constitution of the US, just breached a law of the country. What he did was he was forced to resign because there is an impeachment process against him. In this particular case, I am hoping that Ghanaians grow bolder in their attempts in calling for the president to step aside. Because this is very undermining of what he was called up to do. His very oath of office, he has breached it.
Educate my lay mind. When a president's action is deemed to be unconstitutional and unlawful, is that the same as saying that he has violated the 1992 Constitution?
Yes. In this particular case, that his actions were unconstitutional. If his actions were unconstitutional, then he has in fact violated the 1992 Constitution.
Stricto sensu.
Yes, in every sense of the word. Now that I continue to draw a distinction between a government policy or a legislative measure that violates the Constitution. Because in those cases, there are other agencies which are involved. And so constitutional responsibility for where it went wrong diminishes. In this case, he went ahead and took a decision to ask Domelevo to step aside. When this was challenged, because Domelevo wrote back and says that legally, this is what we have been advised, they didn't even address the legal issues as to why we think we have the power to do what they did. In fact, they said that, well, for challenging us, we're adding 44 more days to the leave we have imposed on you. This is acting with impunity. This is a person who had no regard for it. And we have seen this happen actually before. In the questions of the Galamsey fight, and the decisions to ban excavators in the field, when the law expressly precluded that, the president owned the decision to act lawlessly. And so we have so many instances of this president coming out and acting lawlessly in a way that others will be shy and quiver in the face of. Not even in the most confident times in Jerry Rawlings' regime, where we've seen somebody do certain actions and own it by themselves. So I generally hope that we are, Ghanaians generally take this decision and reflect on what it means to continue to have in the office somebody who has shown a propensity and a disregard for our laws. What does it mean for us as a democracy? And we must sit with that uncomfortable reality.
Now, does this, again, Honorable George Lowe, mean that the current Auditor General is there unlawfully? And again, I'm asking this as a layman. And I'm asking this because the circumstances and the processes that led to his appointment has been described by the Supreme Court as null and void. How does that affect the current Auditor General in terms of his position, his legal position.
Well, let me just give you.
I don't want to get a point.
I got, but let me just give you a clear, practical example. Okay. You know the University of Education issue?
Yes.
Where Professor Reverend Afo Bruni was appointed Vice Chancellor.
Yes.
And then the former Vice Chancellor, who was hounded out of office, got a judgment that he's back. Yeah, Avoke is back.
He's back.
He's back.
Yes.
He's back. Mm-hmm. And Afo Bruni has to go.
Yes.
So clearly, to the extent that Domelevo says he's not interested, we could have seen maybe actions from different perspectives. Now the question is, Domelevo had also proceeded on official retirement. Okay. How does that play in the whole process?
Right.
So it's a give and take, but it's something I also want. I would also be looking forward to being tested. Mm-hmm. Being tested.
So it's a very interesting question.
Yes. It's because
which is the circumstances that brought you here has been described as
Mao knows.
What does that make you?
Mao knows that you can't put something on nothing.
On nothing.
Yeah.
So if there was no vacancy,
to
which you have been appointed,
then
that appointment is questionable.
That's interesting.
Yeah.
That's a very interesting one.
Because it is assumed that at the time Domelevo left office, he didn't leave fully as Auditor General. He had left possibly just assuming that to proceed on leave. And that is where the thing gets very tricky. You see, if President had allowed the system to work, well within the audit service.
In any case, I think the guy had, I think, 2 more years or a year and a few.
Yes. But I'm saying that if the president had allowed the process, where within the audit service board will sit and say, in the absence of so, and you get the letters every day that the Director General is traveled in his absence, Kofi Mensah will act for this, but that is the normal convention within public services. But the president, whilst the man was still enjoying his leave, appointed an acting attorney general. Auditor General.
Yeah.
And by that appointment, it changes the dynamics.
Yeah.
Explain.
Okay. So if you are acting because your boss has proceeded on leave, you are not holding an appointment letter with conditions.
True.
You are just being asked to
administrative.
But where you have been appointed, because the president has the appointive power, so he goes ahead to appoint. It means that at that point, he didn't expect Domelevo to come back.
That's true.
You understand? That's true. He didn't expect him to come back.
No,
so clearly,
but that stands to
in law, that's what we call constructive dismissal.
No, but that stands to reason. Because by the time you're done with your accumulated leave, you would have been on retirement.
You see?
So I would naturally not expect you to come
back. Effectively, your tenure ends on the last day that you are expected to be in office. Okay. And you remember that even then, Domelevo says that I was born in a certain year. They say, oh, you lie, you cried the MP. You were born in this year. Yeah. So clearly, they are just telling you that we don't want to see your face anywhere near that. And I think that it's against all sensible laws in this country. We are not permitted to do that. So, that is why Mao is insisting that these are personal actions taken by the president and not institutional failure. You can say that institutional failure in maybe the earlier case of the law, because Parliament, we expected that Parliament should have stood its grounds and said that we will not pass any law because A, B, C, D, and things like that. There are other...
Like in the case of the imposition of the...
Of course, yes, because the Attorney General's Department acting on behalf of the Executive had presented a bill. The Speaker could have rejected it and says it's unconstitutional, it goes contrary to what our Constitution, which we have said, we are the only people who can pass the law, and then we will not pass it. And so, but everybody went ahead and passed it, and it took the Supreme Court to come and tell us that all that was nullity. So that is the define. But this one, in actual fact, when the president's attention was even drawn to it, he went ahead in a more, I don't care what you think attitude, and hounded the man out of office.
But from everything that you've just said, Mao, it looks like if Domelevo decides to go to court, I mean, he said he won't, but if you decide to sue for damages, he will be smiling.
I mean, I give a lot of respect to Daniel Domelevo on this thing, because it wasn't just a question about saying that, I'm not interested in damages and I'm not going to pursue this, but he posed back a question about the moralness of what has happened by saying that why should taxpayers pay for the actions of a non-taxpayer?
That's true.
And I love that. It's deep and gets us to reflect on the inequities of this democracy that we are constructing. That we have a person in the office who pays no taxes, decides to roughshod on our rights, decides to ride private jets, says I'm not going to account for it, but he has no skin in the game. So I think that the invitation for us to reflect over sort of the constitutional republic that we are building and what the inequities that we have created in the system mean, it's a fantastic thing. And I think that it speaks to the maturity of the individual that even in times like this, he's re-inviting us to think about our republic.
That then again perhaps brings to the front burner the talk about tweaking. Well, I don't know where you stand on this. I know you want us to do something about the Constitution. There are two schools of thought. Some say we want a wholesale tweaking of the Constitution, a reproduction of the Constitution. Some say, well, there are just a few areas that we need to rejig and we're fine. Do you suppose that if we're going to be taking a second look at the Constitution and to sort of, remodel it?
Yeah.
We should look in a situation where when a president takes a decision such as this, he should be made to personally be liable for his own actions. Should we get there?
Yeah. So one of the things, you should know my position on this. We've been advocating for a new constitution forever.
It is deliberate.
In fact,
it's deliberate because I want you to restate it.
in fact, one of and I was in court again on Thursday for my treason trial.
But that call means that you want the constitution. You're looking for a coup d'état. As some people have said.
I was in court for this, and the principal elements of evidence against me is that my public advocacy has always been calling for a new constitution. But see, the fact is, I have always believed that the Constitution is not a suicide pact. That every generation has the inherent right to rethink the laws that govern them and decide their lives, and to form law in their own image. The Constitution was created in 1992 in different conditions than we have.
True.
I have no problem, like other jurisdictions in Ireland and others, where there's periodic review of the Constitution. Because it must live up to the billing, and does it answer people's questions in their day-to-day lives. We constructed a Constitution which thinking is that how do we block another coup d'etat from happening? Right? For so many Ghanaians that live for whom questions of a coup d'etat is a distant memory. So many people were born after the 1992 Constitution. The questions and the things, the demands they are making of their governments and of their states far outspend that. But even on that question, we've lived in this republic where soldiers under this Constitution stormed our parliament. And everybody's kind of turned a blind eye to it about the injury it does to our republic. It talked about the examples of SAL, where people who continue to this day are unrepresented. And I am in court. I am actually at the Supreme Court over Jean Mensah's issue and why he's not been made to step aside. By fiat, the outgone Chief Justice, who are considered a blot on this country's history, decided that even though there was no injunction, there was no demand for injunction, they were not going to proceed with the impeachment process of Jean Mensah unless the Supreme Court decision deciding on a matter which has already been settled, that if you disclose to the public that you have brought a petition against somebody, it doesn't stop the process. They took that matter back to court, and Chief Justice decided that they were not going to proceed with Jean Mensah anymore. And then, obviously, like Domelevo would happen, we would wake up 10 years later and tell us that, nothing should be done. So it is something that, for me, I continue to wonder to what extent has this constitution checked the abuse of power. Now, there's no way we can have a perfect constitution, and I don't claim that we would. But the process of fine-tuning means that we can be able to take account of past excesses and say that, okay, maybe this is the way in which we can better check the abuse of power. And when that fails, nothing stops us to go back to the drawing board. We are building a democracy, and we must constantly have the flexibility of doing that process of reviewing and going back in the past and checking whether we are doing the right thing.
Because if we don't, these things will recur.
In fact, one of the things when we're building some of these cases and going to the Supreme Court was that there are certain persons, high persons in our civil society, who were worried that we're seeing so many bad decisions coming from the Supreme Court that they were fearful that if we went back to court, they would give a judgment which would have a staying effect and chill any attempts at reforming the law. Because when the Supreme Court has spoken, people assume it to be the law, and so do not want to change. If anytime you want to talk about law reform, they're like, well, the Supreme Court has already decided the matter. So we have become even apprehensive of the Supreme Court's role in anchoring the abuse of power in our society. This invites us to think about our constitutional framework critically. For me, one of the things which is even more important, that the Constitution is also about equity. And I am very concerned about equity in general. Because we have a Constitution that says that a minimum of 5% of all national resources to be distributed to the districts across the country. But all development is local. And if the vast majority of this country's resources are not be committed into the localities and the districts, then what we have a situation is whereby we have Accra, all the money being spent in Accra and procurement being done in Accra, even that of the money which is committed to the district, the letterheads the districts are used are awarded by Accra politicians to their cronies in Accra. Contracts about sanitation are awarded to Zoom Lion in Accra for them to go and work in Tamale. It is not decentralizing even revenue and fiscal revenue across the nation, so that we can have a Zoom Lion in North Dai, and you have somebody who handles sanitation in North Dai and builds the local economy. These are intentional ways in which you think about development and you don't centralize it. But our Constitution allows that to happen. So I think that, if we really want to develop, we shouldn't take these things for granted and say that no law is perfect. Of course, no law is perfect. But also law can crystallize injustice. And that's what is happening, I think.
Right. Let me read some messages that have come through. There's quite a number of them. This one here says that the ruling on Domelevo is of no consequence because justice delayed is justice denied. Integrity is something we lack very much in Africa. Kweku from La Paz sends that message, and this one says, in all of this, Domelevo Bruhaha, why are we not talking about his alleged age cheating? But there's no evidence to back that claim that, the man actually provided evidence that he's not engaged in age cheating. But like we said, some persons decided to choose what they wanted to choose, and that's why we're where we are. And then this one says, Mr. Host, with all what is happening in this country, is it possible to have Ghana ruled by CSOs for at least 10 years? Since we have all CSOs in sectors of the country, because our politicians are wicked and are destroying this country. Aaron Nee from Cape Coast. Good morning, have a dream. This country is gradually sinking into a civil war, and we should take notice of what's happening in Liberia. Please, let us all be careful of what we do to each other. Anger is a source of war. You decide not to add your name, quite unfortunately. And Francis says, good morning, Chief. Please ask the lawyers their view on how the present removal of the Auditor General does not warrant him to leave because he, the president, swore to protect and defend the Constitution since he failed to do so. So when it comes back to what you said, in some jurisdictions, some persons would have asked that, he steps aside or call for his impeachment. But, anyway. Salam, why this... okay. Some says, why do we have only NDC and not MPP? So, Ahmed is a very good friend of mine. He works at the Sports Ministry. Ahmed, the thing is, we had invited Kingsley Mwakubwedu from the MPP. In fact, the MPP had asked him to join us. Because what typically happens is that on Wednesday we're done, or Thursday we're done with our topics. We send the topics to to whoever is responsible for dispatching or for deploying party communicators or government communicators. So because this was very heavy on law, Kingsley, who's a private legal practitioner, he also teaches the law. He was asked to come and join us. But unfortunately, he's had an emergency. In fact, he sent a message that said, I shall apologize to my resource persons and you, the viewers, for his inability to show up this morning. So it's not deliberate. I mean, you've watched my show for so long a time. I've always been, I've always been very professional, very impartial. Now, I don't like to say neutral, you see, because we all vote. So this neutral thing, I think it's fake. There's no journalist who's neutral. You just have to be partial, So it is what it is. So you have to be impartial. That's the word I'm looking for. So Ahmed, that's the story. So just in case you didn't know. And then this one, my final one before I say bye-bye. Koku Maulin Nanegbe. He says that, moreover, the irony of the Daniel Domelevo's matter is that it was the president, a known lawyer, on one hand, and the current board chair of the audit service himself, a retired auditor general, on the other hand, who have led to the regrettable hounding out from office of Mr. Domelevo. That irony today is that whilst President Akufo-Addo removed acting the AG, Daniel Domelevo, from office at age 59. He's keeping 84-year-old Professor Diajima as board chair of Audit Service and 72-year-old in-law Mark Sokovijuma as GEHOP CEO. Koku Nane, he sends that he sends that message. And finally, okay, so I guess we're done. So I want to thank you very much, Mause, for your time. And Mause Oliver Baka-Vomawa is a legal researcher at University of Cambridge, and also the Honourable former Member of Parliament for North Dai. That's Honourable George Lowe. He's also a private legal practitioner. I think it's been a very, very insightful and a thought-provoking conversation. I've enjoyed it. I've learned a lot. Thanks for watching another edition of Inside Pages. Same time next week, Saturday, 8 o'clock. Please join us. Have a great weekend. Bye-bye.